Um, all right, welcome. This is Professor Guerra-Pujol from the University of Central Florida, and welcome to the Legal and Ethical Environment of Business, Module B, the Common Law. This is a makeup, if you will, or if you weren't able to attend lab number one. As you know, I'm making attendance optional as per the guidelines of the provost. Thankfully, things are going in the right direction in terms of more and more people being vaccinated and fewer and fewer new cases of the new Omicron variant. But if you still look at the overall number, it's still pretty high, though it is going in the right direction. But nonetheless, just for safety. So let's go ahead and jump in and talk about the common law. And what I was saying before I hit the record button is that the common law refers to judge-made law or case law. The judges play, when we're talking about the legal environment, it's just not enough to talk about the laws and regulations on the books. You have to talk about the courts and the indispensable role that judges play in interpreting the law and in applying law, and in some cases, in the common law tradition, even creating law. And so now what's really interesting about the common law tradition is that it goes all the way back to England and the Middle Ages. And what's really interesting is because England and, as England became Britain and then the United Kingdom, and you had this, worldwide British Empire, almost every English language speaking country that was at one time ruled by the British, they still maintain, most of them, a common law system. And so, probably you may think of, like, let's say Australia and New Zealand come to mind, as countries that have a common law tradition where judges play a really important role. But it's not just those types of countries. In the Caribbean, you have a lot of former British colonies or part of the British Commonwealth. Jamaica comes to mind. Barbados, which recently declared independence, comes to mind. TNT, Trinidad and Tobago, come to mind. A lot of places in the Caribbean that have the common law, follow the common law tradition. Zimbabwe in Africa, there's countries in Africa that have, the common law. Even places as far away as India and Pakistan, because they were once ruled by the Brits, they have this common law tradition where judges play a really important role. And what we're going to see when I go into the module is you're going to see that the common law does refer to these judge-made principles. When you group them all together, and I should say it's judge-made principles, rules, doctrines, legal standards, you name it. As judges decide cases, right, they are figuring out what the rule of law is, or they're applying a rule of law that the legislature has codified, and they're applying that to the facts of the case. And so, these cases, the common law tradition, and the principle of stare decisis, or the doctrine of binding precedent, which is really considered now, the hallmark of the common law system, where one court will look to previous courts for guidance. Now, whether the previous cases are binding or not depend on a whole number of factors. How high is the higher court and what legal jurisdiction are the two courts? We're not going to go into all those details, just to know that courts do look to how cases are decided in the past, and then try to come up with the right rule to decide a case. And we're going to see three examples. But before I do, I want to let you know that the common law, when you look at it as a whole, has three broad areas. They overlap a lot, but these three broad areas are really essential when we're talking about legal environment of business, because the three broad areas are property law, contracts, and what lawyers call torts, which is just a legal word for injuries or accidents. And so these three areas of the common law, property, torts, and contracts, some of them, some of these three areas have been supplanted by legislation, but broadly speaking, the common law still applies. The basic principles of law that we're going to see in this module still apply and are still being applied by courts in the Anglo-American world, and wherever common law is still operative. which is, almost any place where English is spoken or where the British once ruled, like India and Pakistan before the partition. Property rights define what a business firm has dominion over. Contracts refers to the transfer of property rights, and torts, injuries, refer to who's going to be legally liable or financially liable when a otherwise lawful business activity generates unintended harms. That's a really big problem. And now I will say, now before we actually begin, I want to make one more prefatory remark, and that is I have to let you know that contracts, that is, at many law schools, it's a 2-semester course. Torts, in a lot of law schools, that is a 2-semester course. Property is an entire semester, and then there's additional courses like in zoning and urban planning and intellectual property and stuff like that. So I want to let you know what I'm going to do here is just give you sort of an introduction, a survey, bird's eye picture of the common law as a whole and how it is judges decide disputes, and give you some introduction to property, contracts, and torts. Now, one more technical thing, I want to relate this back to Module A and the main sources of law. You may recall we talked about state and local law, we talked about federal law, we talked about international law, and treaties, and we compared and contrasted. Most common law is going to be state law. It's at the state level. It's state courts applying these general principles to disputes in their locality. So this makes the law, it can make it somewhat complicated. Now you have 50 states, so you have 50 sort of common law jurisdictions, and you may have significant variations or tweaks in a lot of these rules and principles that we're going to see in each, among these jurisdictions. The general principles are the same. The idea that there are these 3 bodies of law, contracts and property and torts, but there may be minor or even major variations in each of these, depending on what state you're in, or if we're looking overseas in what common law country you're in, whether you're in England or whether you're in India or New Zealand or one of the 50 states. So that's very, very important. Another complication that we'll see when we do Module D on going to court, civil and criminal cases, sometimes the federal courts apply state common law when they're sitting in what's called diversity jurisdiction, when the parties to a federal case are citizens of different or residents of different states, and it's a state law matter that's being litigated. So, federal courts play an indispensable role in the development of the common law, but federal courts are supposed to apply state common law the way the state courts would. They can't second guess, state common law. So I just want to let you know that this does introduce, high level of, some level of variance and complexity in the U.S. legal environment, because you do have these 50 jurisdictions, right? And so you have, in essence, 50 common law jurisdictions. Now, I would say I'll drop an asterisk as well. Louisiana and the Commonwealth of Puerto Rico as well. These are so-called Napoleonic Code states or civil law jurisdictions. The main difference there is, for all practical purposes, the way the courts operate, judges still play an important role. You still have jury trials, both at the criminal and even civil cases. So the courts in Louisiana and even in Puerto Rico look very similar and operate very similar to our courts, and there's federal courts there as well. But they do have, unlike a common law jurisdiction, the other 49 states, they do have what's called a civil code. And the civil code will have all of these contract, property, and tort rules in it, codified in that code. And so that's really the main difference, that a civil law country, and I will tell you, outside of England, the rest of Europe generally follows this Napoleonic tradition, of having a civil code that has all of these rules. But in the English-speaking world, and in the legal system that the USA inherited after the revolution, and at the founding, is we have this body of case law, and so we get all these principles, from judge-made decisions. So here's what we're going to do. I'll do a screen share. I'll show you first the module. You probably have already been in the module, but I want to show you. I have in there just some things I want to show you, and then what I'm going to do is to make the lecture more efficient, I will, as opposed to a full-blown lecture on the common law, like I say, these are semester-long courses. Each of these subjects, in some cases, they're 2 semester-long courses plus the advanced electives. What I'm going to do here is use the survey results from last week to help teach some of these important common law principles, and then you can also see how the class as a whole thinks about, how the sort of guesses about how the common law operates. So let's just go ahead and jump in here, and I'll do a screen share, and I have that already pulled up. And so what you're going to see in here is you're going to see the home. I updated the banner here. There is some news from about 10 days ago that I forgot to post last week. That Joe Exotic was resentenced. This was the whole thing about season 2, try to open up the case and get Joe Exotic a new trial. So that's not going to happen. The judge did agree to resentence Joe based on the new evidence that was produced as per season 2 in the Tiger King, as you saw. Everybody kind of changing their tune. And what's kind of interesting is that Joe Exotic, you could say he got railroaded again. He was originally sentenced to 22 years in prison. The judge only knocked off 1 year from his sentence. So it's down now to 21 years. Now, of course, it's a little bit less because the time he's already served. But, it looks like Joe Exotic, unless he is pardoned by the president, or unless his sentence is commuted by the president, he's going to be in jail for a very long time. We'll see if an appeal is brought. And if so, we'll see what the grounds of that appeal are, and I'll inform the class. Very hard to appeal. Once you're convicted, it's very hard to appeal a case, and there's going to have to be what the appellate courts call an abuse of discretion or a clear error. And generally speaking, courts are not in the business of abusing their discretion or making clear mistakes. It does happen from time to time. Some cases get reversed. But all I'm telling you right now is that's a very uphill battle, not impossible, but it's a long shot. I can just tell you right now. Now, we'll do more about the legal process and litigation, appellate courts, et cetera, when I do module D. And the reason why, by the way, I wait until sort of the middle of the course to talk about that aspect of business law is because what you're going to learn is that really only a small fraction of cases ever go to trial. And even a smaller slither get appealed, and even a minuscule fraction will end up in the United States Supreme Court. So, I don't want to give over, too much importance to something, that is, I don't want to overblow or exaggerate the importance of cases. Now, cases are important. Those cases that do go to trial, those cases that do get appealed, can establish new rules, reaffirm precedents. But what you're going to learn later on is a lot of cases are settled out of court or are resolved via alternate dispute resolution mechanisms that are becoming more and more popular. So I'll talk about that in a future, in that fourth module in that lab. It'll be lab number 3, if I'm not mistaken. All right, so what I want to do here is just jump into the module. And you can see there's 2 ways of getting to the module. You can either go on this left-hand side, or I'll always, like every 2 weeks, like next week, will be lab number 2. Attendance will continue to be optional, given public health concerns. What I'll do is I'll post next week on the day of the class. I'll post in the afternoon the new module with all the assignments. Those of you who prefer to come to the live class, you're more than welcome to. That'll be next Tuesday or Thursday, depending what section you prefer. You can go to any section you want. I have sections at 4:30, 6, and 7:30 next Tuesday, and sections at 4:30 and 6 next Thursday. And those sections will be meeting, I believe it's room 239, the Collaboration 2 classroom on the 2nd floor of the BA1 building. Probably many of you are already familiar with that classroom. All right, so let's jump into, and then if you can't make the live lecture, I'll do the same thing like I'm doing now. On the Tuesday that we don't have class, I'll go ahead and give a live optional Zoom lecture so you don't miss out on the action. And so let's go into the module. And what I want to show you there is, let's let it load. What I want to show you there is, I put a little Katy Perry in there. And oops, hold on here. We got a little bit ahead of ourselves there, you know what I mean? What I've done here is, this is a sort of a mini lecture that I'll be doing, but I do have a full playlist, you know, if you haven't seen them, you know, going into some more detail about the common law. I have some blog posts on each of the three main areas of the common law. And I also have an audio podcast. All of this, you know, it's about an hour, you know, whether you do the podcast or the playlist video or attend today's lecture, or read the blog post. It should take you, you know, less than an hour, whatever format you prefer. Just want to reiterate that. I'm not trying to overwhelm you. I just want to give you options, you know, whatever you prefer, whatever your style is, you know what I mean? So the three main areas, and what you see here, property, we're going to talk about Pearson v. Post. Pearson v. Post is one of the most famous cases in North American common law tradition, in our US common law. So we'll look at Pearson v. Post, and that's a case that's studied in every single law school, a lot of times on the first day of law school or the first day of your property class, you know, so we'll take a look at that. Now notice, I'm not going to say more about property law because next module C, and the next lab is going to be on intellectual property. I prefer to call it the law of ideas. The common law actually recognizes, and now federal law as well, recognizes the ability of individuals, entrepreneurs, and business firms to own ideas. And that's going to be the most important part of property law. And it deserves special scrutiny, that I have a whole separate module for that. So I'm just going to introduce you to one case here, and we'll talk more about, you know, intellectual property per se in the next class. Contracts, I do want to look at one area of contract law, which is reward offers. When are they legally binding? So this is really important when you have an advertising campaign. You know, are advertising promises legally enforceable? You know, we'll take a look at Tiger King, which has a good example of Joe Exotic making a reward offer in season 1. In season 2, that reward offer goes from Joe Exotic's original $10,000 reward. I think I have a screenshot of it over here. In season 2, you'll see it when I get to the survey. That reward is going to be jacked up to $100,000. So the question becomes, is that, you know, legally enforceable? And then we'll look at there's a famous case involving a Pepsi national advertising campaign. That's a really important common law precedent. So I'll take a look at that case in a moment as well. And then finally, there is tort law. Let me just jump in here. And by the way, I should say while I jump in here, Pearson v. Post, it is really nice. It goes nicely with the Tiger King theme because at issue there is the ownership of a wild fox. You know, so we're talking about wild animals with the videos, although with the contracts, although we're talking about the Pepsi case, you know, we'll launch off with the Joe Exotic reward offer, you know, and look at the similarities there. And finally, torts, a couple of Tiger things. This is from season 1. There's a character called Saf, and she gets her arm chomped off by a tiger. You know, unfortunately, she's only appears one time in season 2. So you probably, you know, unless you watch season 1, but what I've done here is I've supplemented that episode in Tiger King with this case involving cattle trespass. And of course, admittedly, cattle, that's not a wild animal, but cattle trespass is an important aspect of tort law that will teach us some general principles that apply to all injury cases, you know? And so that's why I'm going to use that cattle trespass case that I've assigned is a Florida case. So, and then as you can see, I have blog posts for each of these things. Also, in preparation for the discussion post, which I'll say a few things at the end, I do have a bonus module. I forgot to put the word bonus here, but I have a bonus module on illegal agreements. I've only added this module because I'm personally fascinated by agreements that are either illegal or immoral. And, you know, what do we do with those type of things? Because on the one hand, we have a moral obligation, a duty, if you will, to keep our promises. But on the other hand, we have a moral duty or obligation not to harm other people. You know what I mean? At least not with their consent, you know? And so this raises sort of a conflict. And what I find fascinating about this conflict, it's going to force us to decide between two kind of, you know, a tough choice. And this is really what the common law often has to do. All right, so let's just jump in. And what I want to do is I want to jump in by going to the survey results, and I'll for this module. Now, surveys, I generally keep assignments open for the entire module. That's why I've kept the quiz and the discussion post open until this Friday. Let me just say a few things about the quiz too, because I may forget later. The quiz is open book. It's based on chapter 1 of the textbook, the Melvin Legal Environment textbook. And what you want to do there is, it's open books. I just want you to know the legal lingo that we'll be talking the rest of the semester. Now, that quiz was originally designed for the module A, for the orientation module. But I didn't want to, I already had 2 discussion posts in there and a survey, so I didn't want to overwhelm people. I want to generally have a survey plus 2 assignments. So I just moved that quiz into this module. It's a 10-minute quiz. I'm keeping it open for 20 minutes across the board. Everybody can have the benefit of the extra time. Just a few, I think it's 8 questions. And if you have the textbook, you'll have no trouble. If you don't, if you want to just Google the answers, you can try to do that as well. I don't know how reliable, Google is going to be, you know what I mean? Their search algorithm here. Or if you don't have a textbook and you don't want to take your chances with Google or Wikipedia, I do have many copies of the textbook, the latest edition, on reserve, at the library reserve, at where, the new entrance of the library, the John C. Hitt library. And so you can also just check it out. The checkout times are an hour because it's a big class. And I think there's like 7 or 8 copies, if I'm not mistaken, down there. So you can, you don't have to spend money, I'm saying? You don't need to connect code or anything like that. So it just, I just want you to have access to the textbook. If you already have it, then that's great. Any addition will be fine. And you can learn the basic lingo, the basic sort of, legal terminology. All right, so what I want to do here, just go to quiz statistics, and then I'll use the survey in order to now delve into the common law. And let's just jump in here. Well, actually, let me let this load, because it's a big class, so it may take a few moments to load. All right, great. Now the first survey question is, which party should have prevailed in Pearson v. Post? And this, this is a survey, so I don't care if you've read the case yet. I just want to get your feedback, what your intuition is. This little drawing that I got off the internet, just as a nice visual summary of the case. You have Pearson, who is walking along and just grabs the fox. But the thing is, what Pearson is doing here, he's breaching sportsmanship. He's in complete violation of the sportsman's decorum, sportsman etiquette, or the sportsman code, the hunter. Post, as you can see there with the hounds, Post is hunting the fox, and he's in hot pursuit. He's chasing the fox. And, according to the facts alleged in this case that were proven in the trial court, Post it was just a matter of, he was very close to actually capturing the fox. And so, and I will say, by way of background, one of the reasons why this case goes all the way, based on my own research, the reason why this case goes all the way up to New York State's highest court, remember, common law, state law, but this case is so famous that all the other states have kind of followed this principle here. Or, most of the other states, this is the majority rule we're about to learn. Is that Pearson and Post had beef in real life. It's kind of like Eduardo Saverin and Mark Zuckerberg, if you saw the movie The Social Network, that kind of thing. So that's kind of why they're fighting this case, on a matter of principle, because they don't happen to like each other. What happened to this case is so close after the American Revolution. This case is 1805. American Revolution is 1776, but the war is not, won until 1783. That's when George Washington famously surrenders his command, Probably one of the few times in history, where a military leader does that, setting an enormous precedent. Then you have the Constitution ratified in 1788 by the ninth state. So it becomes law for those 9 states, and then eventually ratified by the first 13 states. And so, the courts here, they're gonna want to come up with their own American common law, not just copy what's going on in England. That's why this is a real big case and really important to our historical development. But you can see what's going on here, right? And it's kind of interesting. What the reason why I do talk about this case and why it's so important, and one of the reasons why it's the first case to be taught in if you take a property law class or law school orientation, because in part it's an important case. Something that doesn't have an owner, what the Romans called a res nullius, a null thing, a owner. How do you acquire ownership in something? Normally it's by contract. You transfer title in exchange for something of value, or you give something as a gift. But what about for the first time? And what's really interesting about the facts of this case is this occurs on public land, and there was no common law rule in New York State, and there was no statute, there was no legislation dealing with, ownership of wild animals on public land. So the court's going to have to resolve this. And here is the larger principle at work here. Here is what really, really matters. And I'm going to end the screen share before I show the results. There are 2 ways the court can resolve this. Either it can adopt a clear-cut, bright line, easy to apply rule. That would be then Pearson, the guy who grabbed the fox. Even though Pearson is a complete jerk, even though Pearson, is in complete violation of sportsman's good conduct, there's no law. This is just a sort of a custom, that is a simple, clear-cut, easy to apply rule, right? First possession. On the other hand, the court could adopt a general or flexible legal standard. And the difference between a standard and a rule is that a standard is more fuzzy. A standard is more flexible, as I mentioned previously. A standard is a special, it's like a legal principle that allows you to take into account all of the circumstances. So for Post to win, for the guy hunting the fox in pursuit, about to effectuate the capture, you would need a standard that would say, if you've invested time and effort in something, you are going to be the owner, and nobody can interfere with your, with the effort that you put in. We don't want to reward people just grabbing stuff. We want to reward effort level. So notice there are 2 ways a court could resolve this. And there's really no right answer, right? Both rules have pros and cons. If you go with a simple, bright line, easy to apply rule, that's awesome, because that's going to be, moving forward. Everybody knows the rule. It's easy to apply. It's clear cut. Boom. This should resolve disputes going forward, But the disadvantage is that it's unfair. It's unfair. Pearson, the jerk, right? Pearson, what the dissent calls the saucy intruder, he's going to get the fox, even though he just grabbed it, without putting any effort into it, and that's the exact advantage of a general, flexible, broad standard. With a standard, you can do justice. You can take a look at all the facts, and you could say, yeah, we want to reward the effort level here, even though Post had yet to actually capture the fox, but he already put in a lot of effort. Back then, I should note as an historical footnote, the fox hunting is now illegal. It's banned even in England, but back in the day, fox hunting was part of a big aristocratic tradition, and it was, it would cost a lot of money to have the horses, the basset hounds, the bloodhounds, the red coats or whatever it is, all the equipment that goes with it, the rifle and ammo, et cetera, et cetera. So it was a very expensive sport, if you will. And so let's see what the class thinks of what the court should do here, or who should prevail. So I'm going to go back into the screen share modality here, and let's see here. Let's pull this up. All right, great. There's the saucy intruder. I found that sticker off the internet as well. I love that description of Pearson. And notice here the class's intuition, the majority here, we had about, I would say here, we had about 90% participation. Probably the 10%, it's not going to affect the outcome. Probably they were unaware that this is only open. Surveys will only be open on the weeks we have the lab. I think I made may have made an exception for the last survey, but that's the general rule, to get people to get the survey done. But notice here, the overwhelming majority of the class prefer simple, bright line, clear-cut rule. First possession, give it to Pearson, regardless of whatever decorum he may have breached. And that is exactly how the court ruled in this case. The court ruled for Pearson and established the doctrine of first possession. What's really interesting, we'll see this in the next module, we'll see how modern intellectual property law has pretty much adopted the Pearson rule of, we'll see an example in patent law, when Congress made some significant amendments. I believe it was in 2010, adopting a first to file rule. It used to be, it was the person to get a patent was, or the inventor to get a patent was the one who had priority, the one that actually made the discovery, not when the filing was, formally introduced into the patent office. Now we have the rule that, no, whoever is first to file, as long as they can meet the requirements that are established in the patent law, that we'll see that in the next module, then they're going to get the patent first, regardless of who has priority of the actual discovery or invention. So this actually is a very, very, it's a very influential rule. And common law courts, as we're about to see, generally often prefer, historically speaking, bright line, clear cut, easy to apply rules. And let me just say why this is so important, because this gives us sort of a paradigm, if you will, a way of judging, modern legislation and modern court decisions. You know what I mean? Are they simple? Are they giving us simple, clear-cut, bright-line rules? Oftentimes they're not, because the legislators or the courts are trying to balance a lot of competing interests. But the common law historically, at least this was my mentor Richard A. Epstein's thesis. The common law historically has been about simple, bright-line, clear-cut rules. All right, so let's go to the next area. I'll say more about property law in the next module because it's so important in the modern contemporary economy. Hopefully Ms. Diaz, my TA, will be moderating the chat. If not, I'll get to all the questions at the end. All right, so let me just go ahead and do a screen share. And there's a few questions now on contract law. And starting with, I think I gave just an example of just ordinary life, these reward flyers, and which of these rewards are legally enforceable. And notice here we can do, right, bright line, clear cut, simple to apply rule, right? If you're going to go in that direction, either you say they're all enforceable or none of them are enforceable, right? Here is a problem with saying that, if you say that they're all enforceable, the problem there is going to be like, look at A, it just says lost dog and it has the two explanation points, So what does that mean? Let's say I find the dog, I call the number, I bring it over, they come to pick it up, what if we don't agree on a reward offer, on a reward, monetary reward for me for finding the dog, can I go to court? Like, it's like, that's going to be kind of a problem. By the way, you may notice B and D, trick questions, those are identical. That those say lost dog as well, has the dog name. Notice there's no mention of a reward there either. E is interesting because it says lost dog and it has the word reward, but it doesn't spell out a dollar amount. And what's really interesting is C is the only one of these flyers that has a specific dollar amount attached to it. And let me tell you, it's not a trivial sum. It's $1,000 for finding that, literally for finding that dog, that puppy. And what's interesting here, if we look at our class results, the majority, when you add both none of the above and A of the above, all of the above, the majority, right, 21 plus 29, that gives you 50%, right, opted for some form of bright line rule. But the problem, like I said, if you say all of the above, how are you going to litigate disputes about what the dollar amount is in E, for example? D, A, and B don't even mention the word reward, you know? E mentions the word reward, but that could lead to endless disputes about how much that dog is worth. You know what I mean? But if you say none of the above, that's also kind of problematic because we would like to incentivize people to find lost pets, and lost valuables, and so maybe the law should, enforce reward offers so that people have an incentive, to do the right thing and return lost goods, And so what's really interesting, the plurality here voted for C. 41% spotted that it was that C was the only flyer here that had an exact dollar amount. And it turns out that is our common law rule. The common law is that, not all promises are going to be legally enforceable. Not all promises are legally enforceable, regardless of what your moral intuitions are. For a promise to be legally enforceable, it's got to be supported. I'm going to use the legal jargon. It's got to be supported by bargained for consideration. What does that mean? Consideration, we're normally used to, like I was saying about decorum and, sportsmanship and, being polite, thank you, polite, kindergarten rules, right? Important rules. But legally speaking, contract law, common law, consideration simply means something of value. It can be money. It can be, a thing. It could be a promise of providing a service that's valuable. But to put it in plain English, for a promise to be, or even a reward offer, for it to be legally enforceable, it has to be supported by something of value. You have to back up your promise by something of value. For a court to enforce a reward offer for a lost pet, that reward flyer is going to have to specify a dollar amount. Now, what's really interesting about the common law doctrine of consideration, notice it's a clear-cut, bright line, easy to apply rule, right? As long as the promise is supported by consideration. And what the courts say is, to keep it simple, is we do not, common law tradition, the courts will not second guess the size of the consideration, the sufficiency or adequacy, whether $1,000 is too much for that dog or whether $1,000 is too little for that dog. No, as long as there's consideration, even if it's just $1, or even if it's $1 million, Bitcoin, so it's several $1 million, whatever, the courts are going to generally enforce it. You know what I mean? Because it's supported by consideration. Courts are not going to be second guess the business skills or negotiation, how it played out, bargaining skills of the party. But the promise does have to be supported by something of value. Now, normally in contracts, that's not even an issue, because you're buying and selling. You have one party buying something, so they're offering money or the promise to pay money in the future in installments, maybe. And then you have another party delivering goods, providing a service. So you have, you're meeting the doctrine of consideration when you have a bilateral contract almost all the time, This becomes an issue when you have these unilateral offers or these reward offers. Now, though, I want to give you a modern case. Before I talk about Joe Exotic's reward offer, I want to talk about the PepsiCo case, because actually, even though it doesn't involve wild animals or animals at all, it's the leading case. And so I want to show you right now the Pepsi TV commercial. And actually, what I need to do is give me 1 second. I thought I had pulled up the Pepsi TV commercial, so I'm going to pull it up right now. It is in the module. But what I think when I opened up the, I closed it. So perfect. I think I found it over here. Let me go ahead and all right. So let's go into the screen share modality now and pull up that Pepsi commercial. Oops, I think I did something wrong here. Hold on, give me 1 second. All right, am I in the share here? Looks like I'm in the share. Perfect. So let's go ahead and pull up the commercial. And ask yourself, is this going to be legally enforceable, what Pepsi's offering in here? Now, there's going to be an ad, so let's go ahead and mute it. Hopefully, let me skip the ad. Yeah, good. I'll be able to skip the ad in just a few seconds. skip the ad and then I'll just expand this. Alrighty. I thought I skipped the ad. Let's skip it right now.
Stuffed catalog. The more Pepsi you drink, the more great stuff you're going to get. Sure beats the boss.
All right, I'm going to end the stop share, and then we'll look at the survey results there. Again, this was a real case. Someone actually, back then there was no internet. It was the 90s. Internet was just coming up, so you actually had to go to the store, Publix, get a copy at the Pepsi, shelf display. This was a big promotion, nationwide campaign. This was a Super Bowl ad originally, you know what I mean? And what was going on here is that somebody then, got the catalog and saw the fine print. The fine print said that you could either, you could get Pepsi points by buying Pepsi products, Pepsi Cola, and what else is there? Mountain Dew, all those kind of Pepsi products. Or you could actually, if you needed, spare points to win merchandise, you could buy Pepsi points. Each point would cost you 10 cents. So some guy figured out, that hey, that Harrier jet is worth $23 million. No way Pepsi is going to be able to get that Harrier jet. So I'm going to get, how much is it going to cost me to get 7 million Pepsi points to get something that's worth $23 million? And it turns out, if you do the math, $700,000 will buy you 7 million worth of Pepsi points. And that's exactly what this guy, Mr. Leonard, did. Him and a few friends of him, they rounded up the money, they pooled the money, they got a certified check for $700,000, and they go to PepsiCo, Pepsi Cola's corporate headquarters. Now, PepsiCo is this big corporation. They own Taco Bell now, Pizza Hut, it's a huge company, not just Pepsi. So we're talking about a billion, multi-billion dollar, one of the biggest, fast food and beverage companies in the world. They go to their corporate headquarters in New York City and say, we want our jet or the $23 million, right? Common law. It's a clear-cut, simple, easy to apply rule. You said 7 million points. Your catalog spelled out that $700,000 will buy you 7 million points. And you have a commercial, that's, where it's all this is, nationwide. So let's see what the class thinks, what the court does. So this case, of course, PepsiCo is not going to pay these guys. They're not going to be able to get the jet, and they're not going to want to pay $23 million. That would be a loss of over $22 million. You know what I mean? And so let's see what the class thinks, how the court should decide. Oops, hold on here. I'm going to have to go back into, let me just pull up the right screen. Survey. Okay, there it is. Okay, great. So I'm going to go into a screen share modality now. There we are. All right, perfect. Let's go ahead and do this. And which party should have prevailed in the Pepsi Harrier jet case? And so, little statement of the facts over here, right? And what's really interesting is notice here, compare it to the flyer, right? A plurality said that it should be C. The bright line rule should be narrowed down to when there's a specific dollar amount, which is the common law rule, the doctrine of consideration. Here, what's really interesting is when faced with just a yes or no, everyone adopted here the common law rule. What's really interesting, though, is that Leonard lost the case. And that's why I like to say that contract law is a 2-semester course, right? Because what the court is going to add is they're not going to overrule. This is a common law, this is common law. This is generations going back to England, this is going back centuries, that's the rule, an offer backed up by something of value is legally enforceable. But the court introduces a general standard here. The offer must be made seriously and not in jest. You know? And what the court concluded here is that the offer, the TV ad, think about it, it was in the Super Bowl, so it's like it was meant in jest. And the kid goes, hey, sure beats the bus, like a punchline. Also, what's really interesting here from a so-called what I like to call a Bayesian probability perspective is sometimes evidence that's not there, the dog that did not bark in that one Sherlock Holmes story, right? Sometimes the absence of evidence is evidence of absence. And when you actually opened up the Pepsi stuff catalog, there's no mention of a Harrier jet, no mention at all of a Harrier jet. So it's further evidence, right, that maybe Pepsi was joking. Now, here is the key question before we move on to our last contract survey question, and then just wrap up with torts and the discussion post. And that key question is as following. How does the court know? Because this was decided, you don't need to know the technicalities, but this was decided on what's called a motion for summary judgment. That means the parties didn't want a jury. The parties agreed what the facts were, so they don't need a jury. They agreed that Pepsi, showed the ad on national TV. They agreed that, the points were worth, 10 cents per point. They agreed that the certified check was bona fide, et cetera. Where they disagreed was on the law. And so the court is going to rule this as a matter of law. But how does a court, or a jury for that matter, how does a jury decide whether something is serious or in jest? And this goes actually back to, I didn't assign it because it's very hard reading, but you may have heard of this guy called Oliver Wendell Holmes. And Holmes, Justice Holmes, as he was spent decades on the United States Supreme Court, famous for his free speech dissents during World War I. But Holmes wrote a book when he was back in the 1880s, 1870s, published in 1881, called The Common Law, while he was still a professor at the Harvard Law School. And in his book, The Common Law, he says, look, the common law has to adopt, and has been adopting, historically speaking, what he calls an objective standard. Like what that means is, in plain English, is in deciding whether the Pepsi commercial is serious or not, or is in jest, we adopt what we call a reasonable person test, or a reasonable person standard, because it's a standard, it's general, it's flexible. We ask, what would the average, viewer of the commercial think? You know what I mean? Now, what's interesting and what's to me is very problematic with the so-called objective test is that, well, Leonard must have thought that and his friends must have thought that Pepsi was being serious, right? Because they put real money on the table. The $700,000 is not nowhere near as much as $23 million, but the courts are not supposed to look at the sufficiency or adequacy of consideration, right? It's size. The courts are just there to see, is there consideration, And he thought the ad was serious enough that he rounded up to $700,000 in a certified check. So I always say, but that's Holmes's point, the law cannot adopt in a subjective standard. It's not what you think, it's what the average person thinks. Now, this is really interesting because now the court or the jury, depending on who the fact finder is in the particular case, will have to kind of figure out, okay, I have to guess or figure out, I don't want to use the word guess, but, have to kind of figure out or, somehow determine what it is that average person would believe, And so here's where the evidence and the testimony and all that stuff will come into play. But ultimately, to me, it's a kind of a close call. It's kind of a close call because there's no disclaimer language, And so you could say, and Pepsi is the more sophisticated of the two parties, you could argue. All right, let's go ahead and do one more survey question on contracts, and then we'll wrap up with torts and the discussion post. And the last one was this one, right? Well, what about Joe Exotic's reward offer? Originally, it was $10,000, but if you saw season 2, they jack it up to $100,000. When I say they, I mean this guy called Ripper Jack. You know what I mean? So is this legally enforceable? And what's really interesting here is that these results here pretty much track our PepsiCo results here, 72%, 28 over there, 70 to 30. But notice there was a 2%, which represents, in terms of number of students, about 11 students, switched their vote here. Because what I love about the Tiger King example, and by the way, Carol Baskin has not been arrested, so this has not been tested in court yet, if Ripper Jack were to refuse to pay the reward offer. But if somebody does provide information leading to Carol Baskin's arrest, that would trigger the reward. On the one hand, this is a clear cut, simple, easy to apply rule. Money, specific dollar amount is being offered as valuable consideration, right? On the other hand, we have to ask, because of the Pepsi case, is Mr. Ripper Jack here, is he being serious? Or is this in jest? Now, my instinct as a lawyer is to say, well, the fact that he has this billboard, you know what I mean, in Hillsborough, Pinellas County, right? That's telling me he's serious, right? Also, Ripper Jack paid a lot of money to put TV ads during the Dancing with the Stars episodes in which Carol Baskin performed. But then again, Pepsi paid a lot of even more money on their Super Bowl money to put their ad, and then followed up by a nationwide campaign. So notice there, we're gonna have to know more about Ripper Jack. You know what I mean? And that's what I mean by a general standard introduces a lot of uncertainty. You know what I mean? Yes, you could say in the case of the Pepsi Harrier jet, example, having that general standard does justice. If Pepsi is just joking, we don't want to really enforce this. And we have a reasonable person test to determine whether Pepsi is joking or not. You know what I mean? But now you have a case like this, and I would need to know more about Ripper Jack. You know what I mean? Let me see. If we go online here, are you seeing my screen? I'm going to just do a Google search for Ripper Jack. And, maybe, we can just do a quick Ripper Jack Media. So this guy has a company. That's his Twitter page. Is that serious? You know what I mean? This is not to be confused with the famous Jack the Ripper serial killer, right? Let's see here. Meet Ripper Jack, the armchair detective from Tiger King 2. So what a good lawyer would do is find out who wrote this article and interview them, right? And conduct their research, maybe even take a deposition. We'll look at all this when we see how cases will play out. So the guy looks legit to me. He looks serious, right? I'm going to agree to this just so that we can go in. And but we'd have to read the article and see, But notice, because now we've introduced my larger point here is because now we've introduced a general standard that the offer has to be serious. Before this, by the way, goes off, I'm just going to close it because I don't know what video is going to come up in there. So let's now complete. Speaking of disclaimers, when are disclaimers legally enforceable? And I wish now I had rephrased the question. I should have asked, should disclaimers be legally enforceable? Because here, most of the class, I'll just say it. This is like election results in North Korea. People's Democratic Republic of Korea. You get I think over there you get like 95% or 99%, but these are like really high numbers. And when I looked at these results, I realized that maybe people were biased because they look at the language. It looks really official. You know what I mean? I actually have, I misplaced it, but I actually had my UCF game day ticket. You know what I mean? From last year's baseball season, but it was so small, even magnifying it. So I just got this one from a minor league baseball park. But let me tell you, not all disclaimers are legally enforceable. And now we're in the area of, technically we're in the area where we're in an area in which accident law, torts, mixes up with contract law, because the idea here is that if you have a well-worded, well-drafted contract, your business firm or you as an individual, if you're doing business, under your own name, you can disclaim your tort liability, right? So I should have asked, should you be able to do that? Instead of, is this legally enforceable? The class really guessed it right. But let me tell you what's going on here. What's going on here is that there's a general standard. And the general standard is, because let me tell you right now, not all disclaimers are legally enforceable. And in fact, because disclaimers are normally, drafted by big companies against, consumers, you know what I mean? And employees and things like that. I think of Saf, when her arm was chomped off, was there a disclaimer in her employment agreement, that kind of thing. Courts will look at the language of the disclaimer very carefully to see what exactly it covers. If you read the one that I gave you in the survey, it's going to talk about basically broken, you're at a baseball field, broken bats and foul balls, baseballs. And so In fact, that is the correct answer. It is legally enforceable, but the courts have adopted a general standard, and the general standard is, and you can only, I'll just put it, you can only disclaim those injuries or risks, to be more broad, that are foreseeable. Now, how do we decide what's foreseeable? Again, we use the reasonable person test. What would an average person be worried about if you go to a ball game? Yeah, a broken bat that can fly into the stands. It's happened before. A foul ball, or somebody missing a catch and it going into the stands, or a home run being hit into the stands, et cetera, et cetera. So those are, a reasonable person would probably say, yeah, those are foreseeable risks. And so that actually is a very well drafted disclaimer, But notice not all types of injury. So there's a great documentary on Netflix called Malice in the Palace. Famous set of events, I think in the late 90s, when a couple of few Detroit Piston players, including Ron Artest, went into the stands and fought some fans. You know what I mean? Because that's so unusual, for athletes to go and punch a fan. Even if it's justified. I'm not saying that wasn't justified. I don't know all the facts of that case. I watched the documentary, but I don't really, I forgot now, how it got set off. But I will say this, you can't disclaim that kind of liability. You know what I'm saying? You cannot disclaim that. Generally, it's not a foreseeable risk. You know what I mean? That fans are going to get into it with the at least back then. Maybe now it is a foreseeable risk because it does. It's maybe it's happening with more frequency. But again, it's the reasonable person test to determine that. Now, there's an interesting exception to a risk that even if it's foreseeable, you can never disclaim. And so I want to share that with you because it's relevant to Tiger King. And that is what the common law courts have called the abnormally dangerous activity exception. So if your business is involved in what's called a quote unquote abnormally dangerous activity, you're not going to be able to disclaim that, no matter how good your lawyers are, et cetera, et cetera. And let me give you the two examples that common law courts going back to England and in most of our 50 states have said are de facto abnormally dangerous activities. Notice it's not just dangerous activities, it's going to be abnormally dangerous. And those two activities are, one is demolition and explosives, right? The other is ownership of wild animals. So what's really interesting is going back to season 1, SAF which was in her employment agreement, because the common law. Now I'm going to make an assumption that Oklahoma doesn't have a special rule. By the way, a quick timeout. I'm getting an unstable internet connection, so if I do get cut off, I have a backup device. So just give me a minute or two. You know what I mean? And I'll use my backup device. Sometimes this happens at night. I know it's during the day, I don't have a problem. But so Joe Exotic, Carol Baskin, for that matter, anybody who runs a zoo with wild animals is not going to be able to, unless they have a special legislative exemption, not going to be able to disclaim legal liability for, injuries caused by wild animals. The rule there is strict liability. Now let's go to our last survey and then wrap up with the discussion post. So I'll go back to the discussion post, to the survey results. And there is this case called Rocco v. Hendry involving a rancher and a farmer. And it's considered the paradigm case of tort law. I love it because it involves cattle trespass. And admittedly, cattle are not wild animals, but they're animals. So it fits nicely into our Tiger King theme, And so the question is, what happened in this case, the facts are very, colorful. You had a rancher, right? He's in the business of cattle ranching. And then you had a farmer next door here in Florida. And the farmer had a chili farm, chili peppers, And so what happened was the cattle, somehow escaped their pen and ended up on the farm and trampled and destroyed a lot of damage, the crops, the chili crops. So the question is, what should the rule of legal liability be here? And what's interesting here is when we look at the results, the vast, a pretty big majority, almost 60% said it should be, look, the rancher is responsible, which, by the way, this is a nice bookend to Pearson v. Post. This is the common law rule. The common law rule for cattle trespass and for trespass generally, when you're on someone's land without their permission, is what the law calls strict liability. The common law calls that strict liability. And let me just say that strict liability is the best example in tort law of a easy to apply, clear cut, bright line rule. Because we don't ask, whether the injury was foreseeable. We don't ask, did the person, allegedly causing the injury, did they take reasonable steps to avoid it? We don't ask any of those general standard questions. We just ask one simple question, although in some cases it's not simple at all, but we reduce the case to one question, to two questions, really, to be honest. Did you cause the injury? And are there damages? And in the case of cattle trespass, right, the courts are going to say, we're going to make the rancher, the owner of the cattle, strictly liable for those any damages that occur to the farmer's crops. Now, what's really interesting, and the reason why I include that case, is because we're not done with the common law. And I want to explain why a lawyer, business lawyer, is always going to be a necessary business expense. You don't want to wait until John Morgan or Diane Newland or somebody like that is suing the company before you get a lawyer, because now you're talking about, okay, how much am I going to have to pay to make the case go away, as we'll see in our litigation module. You're going to want to have a lawyer as early on as possible to have the disclaimer language so that you can reduce your legal risk as much as possible, so that if you do get sued, you're pretty much covered and you have a good chance of getting the case dismissed off the bat. And so here's the deal. The common law rule for cattle trespass, which is what the 59% of the class would have preferred, has been abrogated in Florida and in many other states by statute. Now what we have is a different rule, and the rule is that ranchers are only liable for those damages that are going to be foreseeable. You know what I mean? The problem there is, of course, right, that is going to take the reasonable person standard to determine what type of damage caused by cattle are, reasonably foreseeable. Now, I'll tell you just a brief, you don't need to know this, but, the reason why, like Florida and a lot of other states abrogated, that's to say they revoked the common law rule by legislation, is because most of the accidents or injuries that cattle were involved in involved cars, what I call car-cow collisions. You know what I mean? A lot of cattle were escaping and they're getting on highways, and at night, people are speeding. The lighting is there's poor lighting, if any lighting at all. And so a lot of cars were colliding with, cattle, and, enormous damage to cattle. A head of cattle could be, $50,000 easy. You know what I mean? These are very pricey animals. Damage to the cars were being totaled. Fatalities were occurring, because it's like we're talking about, massive, collisions. And so, should a rancher be liable if a cow goes miles away on some, desolate road and some guy is speeding? You know what I mean? And runs into the idea is the legislation varied the rule, and you see this a lot, like innkeeper liability. At common law, the rule was if you own a hotel, if you're an innkeeper, you are strictly liable for any injury to your guest while he or she is on your property, and your guests as well. And you're also legally liable for any stolen or lost or damaged property of your guests as well. Now, again, that rule, have a lot of hotels in Central Florida and Orlando by Disney, right? Miami Beach, South Beach, So hotel industry, right? They've lobbied, and the legislature, they've abrogated the common law rule when it comes to innkeepers. So next time you're in a hotel, look in the back of the door, on the inside of the room, and you'll see that, language from the legislation where the owner is disclaiming liability, as per the terms of the statute, So a lot of times, the common law, and again, this is why a business firm has to have a lawyer to know, okay, which state law applies and whether it's the common law or whether that common law has been abrogated by a state statute, So you're going to have to know that depending on what states you're doing business in. So then you could take appropriate legal action in your contracts and have the relevant disclaimer language. That's just a big plug for why you need a lawyer. Why a business always, it's just like, paying rental for the warehouse, paying salaries or commission for the employees, all those business expenses. Well, the law is another necessary business expense because it'll save you more time and trouble in the long run. All right. So now let's look at the discussion post assignment. And I'll say a few words about that if, since that is still open. So let me go back into the screen share. And I think that was the last survey question. So yeah, so we'll go back into the module and I'll pull up the discussion post. Like I said about the quiz, it's open book. I just want everybody to be on the same page. I don't even care if you look it up. I just want you to know what the legal terminology is, and some of the main sources of law, et cetera, or reaffirm what we did in the previous module. But for this discussion post, be aware it has two parts to it, and you'll get full credit however you answer, as long as you answer it by Friday. This is the most famous quote of common law in the English language. The life of the law has not been logic, it has been experience. You know what I mean? And what do you think about that? Now, to me, it kind of goes to, yeah, that's why we don't always have clear-cut, bright-line rules. It's why sometimes we have general and flexible standards, right? The common law is trying to balance competing interests and trying to do the right thing, the fair thing. You know what I mean? So I think you've seen plenty of examples, whether it be Pearson v. Post, whether it be the Pepsi case or Rocco v. Hendro case, of the common law kind of in action. You know what I mean? So that's what but you can give your own spin, your own interpretation about the common law. But that is, I want to introduce everybody. That's the most famous quote from his book, The Common Law. So it's so important. He put it on page 1 of his book. All right, and then the last question is going to do here with, you see I have this little collage of vampires and stuff like that. So I was invited to write about vampires one time, and it got me thinking. I was never really into vampires, but I thought the Twilight series was really, really good, and that got me into vampires. And the Twilight series was really interesting because I saw that those were, whether you're Team Jacob or Team Edward, those were ethical vampires, right? They tried to avoid human blood. They would use animal blood, right, in order to keep their immortality. It's got me to thinking that maybe vampires are not necessarily bad. The reason why they're bad, and they use force and violence to get blood, and most of the other vampire fiction, going all the way back to Dracula by Bram Stoker, and Buffy the Vampire Slayer, and all these other President Lincoln vampire, hunter, all that's kind of Black Rain, a great video game, is because there's no legal market for the sale of blood. So now, whether you agree or disagree with me, that's fine. You know what I mean? Maybe blood sales should be illegal. I'll just make a couple of points on this note. There is something called the National Transplant Safety Act, NTSA, of 1984. It's a very important law because Congress made the sale of human organs illegal. So it's a crime, and that pretty much coincides with everybody's intuitions. Also, the sale of human tissue is illegal. However, reproductive, genetic material, egg, sperm, that type of thing, blood, that is excluded from the definition of human organ. So if you look at the other side of the market, like I've been on campus and I've seen flyers where, it says, if you're a young college educated, woman, you should consider selling your genetic material, And my understanding is, I don't know this firsthand, but it can go for like as much as $10,000, for a fertile female egg. You know what I mean? So we're talking about big money there. But blood is in this Netherland, like blood, and let me tell you 2 more things about blood. So the Red Cross, like they do sell the blood to the hospitals, what I'm saying? They have to pay their expenses, right? But generally speaking, you might get like a free gift, tickets, plasma, you might actually get paid for that as well. But there's sort of a taboo against blood sales, that more people compare blood to human organs than they do to, let's say, reproductive or genetic material, And so, interesting. What do you think? I just want to know what you think. Do you think we should have a bright line rule making all sales legal, including organs and, blood and organ stuff? Or should we have a rule making it all illegal, what I'm saying? Or should we just keep the status quo, where organs and tissue are illegal, genetic material is legal, and we leave blood in the legal limbo? It is the gray area. Now, if you want further, in case you don't read my footnotes, the World Health Organization WHO does recommend that the sale of blood not be legalized. And many countries, including, talking about England, United Kingdom, they actually have laws that do make it illegal to buy and sell blood. So I'll say one more thing too. I think is really about, or my book chapter is what it was, part of a larger collection. I think it's really about the drug war. It's really what I was writing about. You know what I mean? Trying to voice my opposition to the drug war in a very creative way. But anyways, what I'll do is I'll close it there. That will conclude the lecture. You've now seen a big picture. You've seen the three main areas of the common law: property, contracts, and torts. And we looked at a number of cases to illustrate how courts decide, disputes involving property rights, or disputes involving whether a promise is legally enforceable, or disputes about maybe disclaimers, or cattle trespass damage. And what I want you to take away is, I don't want you to know the law. Unless you're preparing for the bar or for law school, that's not necessary. But what I do want you to know is that there are these two broad ways that courts decide cases in our common law tradition. They will either go with a bright line, clear-cut, easy to apply rule, or they'll incorporate a general standard, like the foreseeability test, to determine which disclaimers are, legally enforceable, or the seriousness test to determine which promises that are backed up by consideration are legally enforceable. You know what I mean? So what you have in the common law is a mix, and what you have in the law generally, even when you look at legislation and regulations, is a mix of, bright line, clear-cut rules and general flexible standards, And so, which one is better? There's no right answer. It just depends on the nature of the problem to be solved. And those are the two big ways of solving the problem that we've inherited, problems from our common law tradition. All right, with that, I'm going to open it up to questions, comments, or concerns, and we'll jump into the chat as well, just to see if anybody has raised any additional things. The surveys the surveys are associated with the lab. You know what I mean? And so what you want to do now, if you're unable, if you missed a survey, what you want to do is you want to, and if you don't have no health considerations, you want to just go in to my to the labs, because what I'm doing is I'm giving extra credit. It's going to happen. You're going to miss an assignment. You know what I mean? You're going to, that can happen to anybody. You know what I'm saying? So if that does happen, you want to go to, each of the classes. You can get up to 5%, of your grade, and I'll basically forgive a missed assignment. So if you missed a survey or whatever, but the survey will generally be open on the weeks that we have the labs, you know what I mean? And then the assignments, quizzes, or discussion posts, or combinations thereof will be open for the full duration of the module. Any other questions, comments, or concerns here? Other cases. Let's see here. Yeah, there are a number of leading cases here. The priors, by the way, let me answer this other question first, which will be easier for me to answer. Good point. I had included a link to the prior Zoom for Module A, but I just realized when I updated the module, Module B, I may have deleted the link. So I'll repost it again. I'll put it back. It should be in Module A. If it's not in there, I'll put it in there tonight. So you'll have access to the previous Zoom optional live lecture. Remember, these are optional if you can't make it in person or you want to again. Now, yeah, there are, the thing is, the common law, like I say, it's literally, not hundreds, not thousands, not tens or hundreds of thousands. When you go back and you look at all of these, because at law school, you're studying not just American common law, but also English common law, some old cases. So you have this huge population of millions of cases, and law professors, what they're doing is they're selecting just a small handful, in each of these areas of law, to illustrate some of the more difficult challenges, So I will tell you some of the perhaps the leading common law case. I'll put it in the chat. There's a good Wikipedia on it, and I'll go ahead and put it in here. And I may have lectured on it in a different class, so I'll see if I find that lecture. It's called the Palsgraf case, Palsgraf versus Long Island Railroad, LL. I'm sorry, RLIRR. Palsgraf. I spelled that right. So that's considered it's more recent, 1920s, but it's considered a very leading common law case, because they're the Judge Ozo and the dissenting judge, Judge Andrews. They battle explicitly over whether the court should adopt a bright line rule or a general standard in deciding whether the injured plaintiff should get compensated. If you want to stay on, I'll talk a few minutes about the Palsgraf case. and illustrate that, because that's probably of a case that I've omitted, probably the most famous case. There's also another interesting case out of Florida called oh gosh, I forgot the name of the plaintiff, but it's called the Dorado Beach Hotel case. So this one guy was gambling in Puerto Rico, and where gambling is perfectly legal at the Dorado Beach Hotel, one of the nicest hotels actually in the world. It's a beach hotel, it's a beautiful place, and he was a high roller, so he was basically forwarded some money, and he went back to Florida, said he would pay them back, but when when the hotel tried to collect, he said to the hotel manager, well, you know what, in Florida gambling is illegal. Now, I know that's different now, we have the Seminole tribe and stuff like that, but back, this case was in the 1960s, and so he said gambling was illegal. And what's really interesting there is that the Florida courts, this was litigated in Florida, because this guy lived in Florida and he never went back to Puerto Rico. He was a tourist. What ended up happening is the Florida courts, perhaps you won't be surprised to learn, is that they ruled for the Florida resident. They said, because gambling is illegal in Florida, at least back at that time, as a matter of public policy, we're not going to enforce that contract, even though there was consideration. The hotel gave him something of value, the chance to win money, and this guy, bet value, which he promised he would pay back, and everything was serious. Casinos, if they're not serious, they're not going to make money. So it's a very famous case about public policy. And it kind of goes to illegal agreements, and the court said there that in Florida, gambling contracts are illegal, unless you're at a designated Indian reservation, recognized by federal law, an enclave, then, that's a different story. But because gambling contracts were generally illegal as a matter of public policy, we're not going to enforce it. And so that's, it goes to show you that without, legality, you can't have contracts, you can't have a market. That's why the common law is so important. On the Paul's-Graf case, Paul's-Graf is super important. What it was really interesting. It's a convoluted set of facts, but this lady was with her daughter, and she was going to take the Long Island Railroad from New York City, from I think the famous. By the way, it's a crime that Penn Station was torn down to make Madison Square Garden. That is the crime of the century, architectural crime of the century. Penn Station was one of the most beautiful train stations in the world. You know what I mean? But anyways, she's on the platform waiting for a train, and her train hadn't yet arrived. A train was about to depart, and these two guys, the court describes them as Italians. These two guys get on the train, and whether they were Italian or not, the court thought that we're going to have to mention that fact, and they were carrying bundles of in a newspaper. And what happened is the train was about to leave. The train was full. The Long Island Railroad conductor, one of the employees of the railroad, pushed the two Italian passengers into the moving train. The bundle fell, the package fell. It turned out they were fireworks, or even a small explosive device. Like if you know about Tarpon Springs and the tradition of Greek bombs, these are pretty powerful things, you know what I mean? And the bomb set off an explosion, and that explosion, about all the way on the other end of the platform, caused Publix, they have those scales where you can weigh yourself. It caused the scale to tip over. So this was a massive explosion for a scale that heavy. It was one of these old school Publix style scales, fell over, hit the lady. And while the lady didn't have any physical injuries, she got a speech impairment as a result of her injuries. And so she had a stutter. And so what's really interesting is the court said, in order for there to be legal liability there, you have to be in the zone of danger. In other words, who do we owe a duty to? Who do we, we have to avoid foreseeable injuries, but if a foreseeable injury occurs, we're only legally liable if the person was in the zone of danger. So the majority of the court said, the lady was so far away from where the explosion happened that she was not in the zone of danger. Clearly, that's a wrongly decided case. And the reason why, so that's why I don't assign it myself, because it's clearly, like today, that case, there's no way it would turn out that way. But the reason why that case is studied in law school is, first of all, to trick students. Students are going to fall into the trap. Oh, it's the majority, so it's got to be right. That case was the courts quickly distanced themselves from it. But also because of Judge Andrews' dissent, where he says that the law we have to have clear-cut, simple standards here. Simple rules. I'm sorry. And so, as long as the injury was foreseeable, that an explosion could create a reverberation and things could fall, and something did fall, boom, then the railroad is legally liable to the lady for her injuries. Now, this case is also famous because the plaintiff was a woman, and so the case has been used to kind of show that, when the law was a male-dominated profession, on the bench and at the bar, that these unfair results would happen. You know what I mean? But regardless of whether the plaintiff was a woman, the injured party was a woman or a man, I think the case was completely wrongly decided because even if you applied the zone of danger test, she was clearly in the zone of danger. You know what I mean? She was on the platform. Admittedly on the other end of the platform, but she was on the railroad platform. It's not like she was out of the train station and this happened randomly. You know what I mean? No, she was in the train station. So I thought the court was being, I thought the court misapplied the law there. But that zone of danger test is very, very famous because it's now the minority rule. Even New York has abandoned the zone of danger test, but the zone of danger test is a great way to illustrate a general standard and contrast that from a simple, easy to apply, bright line rule. So those are some famous cases. And I could go on and on, believe me. These are, like I say, semester long courses. In the case of contracts, I took it 2 semesters with Professor Anthony Kronman because it was such a great course, even though the second semester was an elective. When I used to teach at the Pontifical Catholic Law School, torts, I taught torts was a 2-semester class. So it gives you some ideas. I could certainly go on. The cases are really fascinating. And that's the larger point I want you to take away. Common law is case-based reasoning. The fancy term is called casuistic reasoning, but you don't need to know the fancy term, case-based reasoning. In other words, we have to apply the law to the facts. Sometimes lawyers will say, we apply the facts to the law. But however you like to frame it, law to facts or facts to law, the common law tradition is very sensitive to the facts. Even when you're talking about a easy to apply bright line rule, you still need to know what the facts are. Who grabbed the fox first. And so lawyers, 90% of their job, is in getting ready for a case or in advising a client is finding out what the relevant facts are. But here is where here's the rub. Here is kind of like the circularity of it all. To know which facts are relevant to the case, to the outcome of the case, to know which facts are relevant when you're advising a client about how to move forward to avoid a legal risk, you need to know what the law is, right? Because what's relevant will depend on what the operable legal rule is. And so because you have common law in each of the 50 states, it's state law made by state court judges or abrogated by state legislation, then you really need a lawyer licensed in your state in which you're doing business in order to know ahead of time what the common law is, which rules have been modified by legislation, and then your business can proceed accordingly to minimize as much as possible, foreseeable legal risks that could happen. So common law, we could go on and on and on. Now we'll see some more cases when we look at the law of ideas, and we'll look at some more cases when we look at the, I'm going to talk a little bit about the Facebook, founding of Facebook, just to mix it up, and not to talk about Tiger King all the time when I talk about litigation. Many of you may have seen The Social Network or be aware that Mark Zuckerberg was sued by his business partner and by some business rivals, almost immediately from when he founded the company. So, we'll talk about litigation and we'll talk about how lawsuits proceed. So we'll talk more about cases then and there. Great. So I think with that, I'll stay on. It is a great movie. Aaron Sorkin, I read an interview with him recently in The Hollywood Reporter. He is considering a sequel to The Social Network, one that would update the movie to current times. One blind spot in the movie is, a couple of blind spots in the movie, but one is that back then Facebook was very popular. You know what I mean? It's kind of like what TikTok is today, but Facebook has had a series of public relations disasters, over the years. TikTok is going through something of that, as well. And so, it'd be interesting. I hope Aaron Sorkin, who is a great movie maker, he did win the Academy Award for the best adapted screenplay for The Social. It's a really good movie. Let me tell you that. Also, if you want a good beach read, let me see if I have it over here as well, or spring break or summertime. It's based on the book called The Accidental Billionaires. And let me say, as good as the movie is, The Accidental Billionaires, the book is even better. And don't get me wrong, it's a good movie. I'm not trashing the movie, but that's how good the book is. So I'll put that away later. So anyways, great. So thank you all for being on board here. By the way, let me not forget to end the recording and go ahead and shut this